We're going to go now to Ms. Brennan Krohn.
Thank you. It's a tough act to follow. Chair Blumenthal, Ranking Member Cruz, thank you for inviting me to speak today and for convening this hearing. My name is Zoe Brennan Krohn, and I'm a staff attorney at the ACLU Disability Rights Program. Britney Spears' high-profile case battle to get out of conservatorship was the first time many people in this country had heard of conservatorship or guardianship, and I'll use those terms interchangeably. But guardianship is, as we've heard, a widespread phenomenon. It's estimated that courts have stripped 1.3 million people of their civil liberties. The most unusual thing about Britney's case is the attention it's getting. Spears' experience of getting into a guardianship in a period of crisis, then facing a Kafkaesque maze to try to get out, is astonishingly routine. Guardianship is fundamentally a civil liberties issue. It is the government stripping away a person's civil liberties and autonomy. It has been called a civil death. If you are under guardianship, you cannot decide where you will live, who you will spend time with, who you won't spend time with, how you will earn and spend your money, or what medical care you will get. And guardianship is fundamentally a disability civil liberties issue, because only people with disabilities, or perceived to have disabilities, risk this type of civil death. People with intellectual and developmental disabilities, psychiatric disabilities, and older adults who age into disabilities like dementia are at particularly high risk for guardianship. Guardianship is a major invasion by the government into a person's life. It's dangerous to be in a guardianship. The enormous power of the guardian, coupled with the lack of transparency and oversight, is a recipe for abuse, neglect, exploitation, and harm. I want to be clear that many individuals involved in guardianships are acting with the utmost good faith and integrity, but systemically, guardianship is dangerous. Yet the harms and risks of guardianship stand in alarming contrast with the routine approach that courts take in establishing them. Guardianships are often established as a matter of course, with few of the due process protections that should accompany such an invasive loss of rights. Notice, opportunity to be heard, access to counsel, and mechanisms to end a guardianship are often entirely absent or, at best, inadequate and inaccessible. Many people have lost their civil liberties without having any idea of the gravity or permanence of guardianship. We need to change this system. We need to strengthen due process protections and treat guardianship like the invasive last resort that it is. And we need to make changes beyond guardianship, towards a world in which far fewer people are in guardianship and far more people with disabilities live self-directed, autonomous lives with the supports they need and want to do so. Part of this requires changing our conception of independence and recognizing that none of us live truly independent lives. We are all interdependent. We all rely on others, friends, lawyers, staffers, reminder apps on our phones, to live our lives. People with disabilities use these same types of supports. Some people have more significant support needs, but they also have preferences and wishes and values. We need to strengthen and encourage structures in our society through which people with disabilities, like those without disabilities, can get the supports they need and want to live their lives consistent with their own preferences, all while retaining their core civil liberties. Supported decision-making is a key model for this, and my colleague Morgan Whitlatch will give you more information on this. While guardianships are primarily established by state law, Congress can and should change this system. First, Congress should set up guardrails to strengthen the due process protections within guardianship. It should recognize and remedy the constitutional violations that pervade guardianship proceedings. This includes identifying and enforcing minimum due process rights, including a right to accessible notice, a right to counsel, meaningful participation in a hearing, and meaningful access to counsel and support to dissolve existing guardianships. Because guardianships have existed in the shadows for so long, Congress should also fund data collection so that we know who is under a guardianship, public education on the risks of guardianship, and monitoring of state court systems to reduce their use of guardianship. But Congress should also take steps to strengthen the world of voluntary support and self-direction outside of guardianship. Congress can and should recognize and advocate for alternatives like supported decision-making, which allow people with disabilities to get the supports they need without government intervention or losing their civil liberties. Congress should encourage the Department of Justice and other agencies to formally identify supported decision-making as a reasonable modification and a less restrictive alternative that must be tried before guardianship. Thank you, Senators, for your interest in this issue and for holding this hearing, and I look forward to your questions.
Thank you very much.